All right, today we're going to discuss bankers-customer relationship. Now, in this relationship between bankers and customer, first of all, we're going to understand the meaning of a banker as well as a customer, and also duties and rights of both the banker and the customer. Okay, in this kind of relationship, both parties are bound to some specific duties and rights. Okay, so according to the BOT Act of 2006 as well as the Banking and Financial Institution Act of 2006, a bank simply means an entity that is engaged in the banking business or the business of banking. So the question here is, what is the business of banking? The business of banking simply means the business of receiving funds from the general public. Okay, so the fund that is received or mobilized by the bank is from the general public. So bankers mobilize funds from bank customers. Okay, bankers mobilize funds from the bank customers. All right, how? Through acceptance of deposits, which is payable upon demand, or after a fixed period, or after a notice, or any similar operation through the frequent sale of placement of bonds, certificates, notes, or other securities, and to use such funds in whole or in part for loans and investments for the account of and at the risk of the person doing such business. So this is a definition of a bank. Okay, now what about a banker? Okay, so a banker is an individual who is working for a bank. Okay, a banker is an individual who is working for a bank. Therefore, if a bank is engaged in the business of banking, it means now an individual who performs the business of banking is simply a banker. All right. Then we have customer. Who is a customer? The word customer was derived from the word custom, which means a habit or a tendency of doing things on regular basis. Okay, it becomes a routine, all right, but in a particular manner. That is how the word custom was derived from the word custom. Therefore, it is generally believed that any individual or an organization which conducts banking transaction with a bank is a customer of a bank. However, if we want to comprehend a customer of a bank, then we need to understand the following four scenarios. Number one, a customer of a bank can be any individual who maintain an account relationship with a bank. Okay, an individual who maintain an account relationship with a bank, we simply call them existing customers. Okay, we simply call them existing customers. An individual who maintain any accounting relationship with a bank is simply a bank customer. But also, a bank customer can be an individual who had, okay, an individual who had accounting relationship with the bank. All right. Look, in number one, we say a bank customer can be an individual who currently maintain an account relationship. Right. That is to say, if right now you have an account with NMB Bank or TCB or CRDB, whatever, then you are indeed that particular bank customer. But what if you had an account? That means you had an account and for some reasons you close it down. Then you become a former customer of that bank. Therefore, even though you do not currently have an account with that particular bank, but still you are a customer of that bank simply because you had an account with that bank. All right. Then 3, bank customer can be all those individuals who do not maintain any account relationship with your bank. Okay, all those individuals who do not maintain any bank account relationship with your bank. However, they visit, okay, they visit your bank branch in order to avail different banking services or facilities that you offer. Okay, all individuals who comes to your bank to access or to enjoy other banking facilities or banking services that you offer are also your customer. So not necessarily they possess an accounting relationship with your bank. If an individual comes to purchase a draft, to deposit a check, okay, then that individual indeed is your bank customer. Okay. And the fourth category, we term them as prospective or potential customers. Who are the prospective or potential customers? The prospective or potential customers simply means all those individuals who have approached your bank with an intention of opening a bank account. That being the reason, you as a banker has already collected their informations. Okay, you know that in banking we're supposed to collect the KYC, all right, to fulfill the KYC for our customers. Therefore, you have either given them a special form where they have duly filled their informations, or you have interviewed them and fill in their information in your system. So even though you have not yet opened an account for them, but the fact that you have already collected their informations, then indeed they are your customer. Right. Therefore, if you are to ask, how do we categorize bank customers, then you should remember those four categories. Okay. A banking customer relationship is a trust-based relationship. Ladies and gentlemen, this is very important to comprehend. Okay. This is very important to comprehend. A banker-customer relationship is a trust-based relationship. Why do we say this is a trust-based relationship, and why is it so important for you guys to comprehend? We as bankers, we offer services, all right? We as bankers, we offer services. And we all know that service, okay, any service has intangibility character, okay? Any service has intangibility character. That means that no one can own a service, okay? Again, we do not have a physical evidence, okay? There is no physical evidence of a service, all right? There is no physical evidence of a service. So, for instance, if an individual says, I have a bank account with, let's say, NMB, the question is, can they show you this account? Okay. If someone says, I own iPhone 14, I own iPhone 14, prove to me, then they can physically show you iPhone 14, right? But if they say, I have a bank account with NMB, can they prove it to you? Can they show you? They'll just give you a bunch of numbers, goes like 1, 2, 3, 4, X, 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 Y, you see? But does this number really prove that you own an account? Can you show it to me? No. But now, since we do offer services, somehow or sometimes we try to provide some document to our customers that at least can bring the intangibility character of the service that we offer. All right. For instance, if someone has a current account, sometimes we give them what? A checkbook. Okay. At least to show that intangibility character. But technically, they do not own, they do not possess this account. Okay. Now, since there is no physical evidence of whatever the service we are offering to these customers, then trust is of highly important. If an individual, a customer does not trust you, they'll never bank with you. Remember, they are coming to entrust their money with you. They want you to keep their money on their behalf. Okay? That being the reason, you really need to have like a good language, nice appearance, good chatting or relationship with the customer, nice working facilities, etc. Why do we do all this? The reason behind is to earn these customers' trust so that they can come and bank with us. If a customer is suspicious even for a single reason, If you give a customer a reason to be suspicious, immediately they'll withdraw all their funds from your bank. And if they do not have an account with you, then they'll never come to open an account with you. You see? And that's the reason the central bank has been entrusted with the mandate to regulate, to license and regulate bankers' activities. Why? In order to prevent a financial panic. Because financial panic can lead to a very serious catastrophe. Right? So it's very important to remember that a banker's customer is a trust-based relationship. Okay. Now, this relationship will depend with the nature or a type of transaction. Okay, so there are several bankers customer relationship, but all these relationships are defined by the nature of the transactions. And again, it is the kind of the transaction or the nature of relationship that will define the terms and the conditions that needs to be adhered to by both the banker and the customer. So, rights and obligations of a banker or a customer towards one another are highly defined by the nature of the transaction that has formed the relationship that we are talking. All right, therefore, the banker-customer relationship can be a debtor and creditor, pledge and pledgee, licensee and licensee, bailor and bailee, hypothecator and hypothecatee, trustee and beneficiary, agent and principal, and advisor and a client. Shortly, we're going to discuss in detail all these types of relationship, all these categories. Okay, we're going to discuss them in detail, and afterwards, we're going to have a discussion on duties, rights and duties of both banker and a customer. All right. Now, let's begin with a debtor-creditor relationship. When a customer opens a bank account, we usually expect that a customer will finally deposit. Okay, if let's say Freddie comes to your bank and open an account, right? The next step is that Freddie is supposed to make a deposit. Okay, Freddie is supposed to make a deposit. The moment Freddie deposits his money, okay, in the open account, it means Freddie has lent his money to the bank. Okay, that being the reason, the bank can be said that it has borrowed the money from Freddie. So, Freddie becomes a creditor of the bank, whereas the banker becomes a debtor of Freddie. That is the basis of the so-called debtor-creditor relationship. That is, when a customer opens an account with the bank, and if the account has a credit balance, then the relationship is that of a debtor and a creditor, where a banker becomes a debtor and the customer becomes a creditor. In case of savings or fixed deposit current account with credit balance, the banker is always the debtor and the customer is the creditor. Okay. The customer has a right to demand back his money whenever he wants. Okay. A debtor-creditor relationship. Okay. A debtor-creditor relationship is formed when, okay, is formed when a customer open a bank account and deposit funds, right? A debtor-creditor relationship is formed when a customer opens a bank account and deposits some funds in that particular account. Consider the following scenario. We have a bank customer, okay? We have a bank customer. And here we have a banker. All right. Now this customer deposit some funds into his bank account. Okay, let's assume he has deposited 100,000 USD. Okay, technically, the banker has borrowed customers' funds. Technically, the banker has borrowed customers' fund. Now, if the banker has borrowed customers' fund, okay, in the book of accounts of the banker, okay, the customer appears as a creditor. Again, in the book of accounts of the customer, a banker appears as a debtor. Why a customer appears in the book of account of the banker as a creditor? It's because the bank owes the customer some money. And in this instance here, the banker owes this customer 100,000. In another way around, I can say the banker has borrowed, okay? The banker has borrowed 100,000 USD from this customer. Or put it this way, the customer has lent, okay, this is a loan. So the customer has lent 100,000 USD to the bank. Remember, ladies and gentlemen, banking business, okay, is a leverage business. Okay, leverage is not enough, is high leveraged business. Why we call it banking business is a high leverage business? Is a high leverage business simply because bankers do business by using borrowed funds. Okay, you do not use your own funds to do business. You are using depositors' fund for the business. The deposit that you mobilize, okay, the deposit that you mobilize is the one that you use for loans, is the one that you use to invest in marketable securities such as the treasury bills and treasury bonds, plus any other instruments that you purchase. The capital of the bank, please understand this, ladies and gentlemen, the capital of the bank is there to serve as a cushion. A cushion for what? A cushion to absorb loss. If you have many bad debts, okay, then it is the capital that is supposed to compensate the losses. We do not use capital as the primary fund for issuing loans or as the primary funds for investing in marketable securities. Unlike other businesses, for example, if you open a mango shop, if you open a restaurant, if you open any other business besides the banking business, you're going to have to use your own capital. You have to inject capital. The capital, the fund that will inject into your business is the one that will purchase some utensils, is the one that will purchase some furniture, is the one that will pay maybe even salaries, etc., etc. But it's different when it comes to the business of banking. If I'm to take you guys back to the global financial crisis of 2007, okay, during this time, we were using Basel II Accord, okay? We are using Basel II Accord to monitor different activities of a bank. And Basel II Accord had a specified amount of capital that bankers were required to keep all the time. Call it the capital adequacy. Right? But following the global financial crisis, sometimes we call this the credit crisis. Why do we call this credit crisis? because it was due to the collapse or the failure of the what? Of the subprime mortgage. Okay, these instruments, the CDOs, okay, the CDOs, this market collapsed. And because bankers, according to Basel II, bankers has less amount of capital to absorb all the losses, many banks collapsed. The first bank to collapse was the Lehman Brothers Bank. Okay, this was the first bank to collapse. Why Lehman Brothers collapsed? Because of severe losses it suffered from the subprime market. That is the reason now. That is the reason when we adopted, when the Basel III was adopted, okay, Basel III advocate for capital, the capital adequacy to be raised. Remember, gentlemen, ladies, 20 years ago, 15 years ago, okay, in Tanzania, with 5 billion Tanzanian shillings, you could open a bank. I'm sure you guys remember this. But now, how much do you need? You need 15 billion to open a bank. Why from 5 billion to 15 billion? 3 times. Implementation of Basel III Accord. And that is the reason, again, I'm going to take you back. Remember 10 years ago, 20 years ago in Tanzania, how many banks were listed at the Dar es Salaam Stock Exchange? I think only 2 banks, domestic bank, only 2. The National Microfinance Bank and CRDB. These were banks that were listed. But Basel III wanted banks not only to raise the capital, but also the huge part of the capital to be equity capital and not debt capital. Why? Because we saw from the global financial crisis the effect of depending or overdependence of the debt capital. So Basel III advocate for equity capital. All right, that is the reason now many banks in Tanzania got listed to the Dar es Salaam Stock Exchange in order to raise this equity capital. And those banks which could not raise the 15 billion that was required were closed down. And remember Mwalimu Bank, which is currently Mwalimu PLC. Okay, Mwalimu PLC went to the Dar es Salaam Stock Exchange, get listed in order to raise what? In order to raise the required capital. Okay. So what I want you guys to understand is that capital of the bank is there to serve as a cushion to absorb losses that you will suffer if you have made some serious losses in the credit market. Now, what if capital is not used for the business? What fund do you use for business? You use depositors fund. That is to say, you come to us, you convince us that if we deposit money at your bank, you're going to pay us a certain interest at the end of the year, let's say 3% per annum. While you take my money, you issue it to somebody as a loan at an interest rate of 20%. You make hell of a profit from my money, and at the end of the day, you pay me only 3% with a lot of conditions. And every time I want to make a withdrawal, you charge some fees. But the money that you are using for business is not yours, it is our money. And again, that is the reason. If it happens, all your customers come at once in order to make a withdrawal, no bank will stand. You will simply collapse. Because many banks, for instance, last time I checked on the financial statements, National Microfinance Bank of Tanzania had utilized 75% of depositors' fund for loans. That is to say, if these customers face this bank asking to make a withdrawal, NMB can never sustain such demand. It will collapse. But there is a technique that we as bankers use in order to avoid this scenario, in order to avoid, we call it bank run. Okay? we call it a banker. Therefore, at all time, if a customer account has some money in it, then you as a banker is a debtor of that particular customer, and a customer is your creditor. Why are you a debtor? Because you owe that customer some money. And I want you guys to understand this. The customer has a right to demand back his money whenever he wants. Okay? However, there is a condition here. We're going to discuss this later. But if a customer wants to make a withdrawal, you have to honor customer's request. That's the reason customer's deposit can be demand deposit or time deposit. With a demand deposit, there's no excuse. If I want my money, you give me back my money. With time deposit, then a customer needs to wait until this fixed deposit matures. So they have to wait until maturity. On maturity, no question. You're going to have to inform the customer that your account has matured. And if the customer wants to make a withdrawal, you have to honor customer's request. Again, since the banker is a debtor, he may use the deposit fund as he wishes. So this is a caution to a customer. Okay, this is a caution to a customer. That is, the moment you entrust your money to the bank, you cannot restrict the bank from using it. The bank or the banker can use his customer's money however it pleases. And this ruling was given back in 1848 in the case between Foley and Hill. So I want to go through the case, but I want to understand that if you are a customer, you cannot restrict the banker from using your money. In case of a loan or an advance, the relationship changes. Okay? In case of a loan, that is to say, if this gentleman here is a banker and this one here is a customer, and a banker has granted a certain loan, okay, to a customer, then a banker becomes a creditor, whereas the customer becomes the debtor. This relationship will continue until the customer has duly fulfilled his contractual obligation toward that loan. That is to say, if the loan is for 3 years, then this relationship will continue until the customer has paid the entire principal amount plus its subsequent interest. There is where this relationship will stop. So, a banker can be a debtor, and the same banker can be a creditor. It depends with the circumstance. When does the banker become a debtor? That is when he owes the customer some money. When does the banker become the creditor? That is when the banker issues an advance or a loan to the customer. The debtor-credit relationship of a banker differs from commercial debts. When I speak of the commercial debts, that is any other debts besides the one that involve some credit facilities. Now, how does it differ? It differs because in a banker-customer relationship, the creditor, that is to say the customer, must demand payment. That is to say, if a customer deposits their money with the banker will never ever make a call to the customer, convincing them to come and make a withdrawal. I'm sure you guys will agree with me. You are very happy when you see that the money that I've deposited in your bank stays there. Why? Because when you have available funds at your disposal, it is when you will be able to issue many loans as possible. So, the creditor must demand payment. Okay? Otherwise, the banker will never pay the debt. Again, in case of a fixed deposit, the bank must inform the customer about maturity. We discussed this. However, once the customer has been informed that your fixed deposit has matured and does not come to claim for it, then the banker can never charge the customer, asking for the customer to make a withdrawal. But when the banker is the creditor, see how they chase customers to ensure that the loan is repaid back. So you can see how it plays out. The creditor must demand payment at the right time and the right place. Okay? The banker, the creditor, who is the creditor? The creditor is the customer. Okay? So, number one, the creditor must demand payment. But not just demand payment. No, again, the demand for payment must be at the right time and right place. Now, I'm going to speak this in two perspectives, the old technology and the new technology. During the old time, this one was highly applicable. That is to say, if you open an account in Mwanza, Rock City Mall, you cannot go to Nyegezi or Moshi or Dar es Salaam and make a withdrawal. We discussed this in the previous session as well. You have to go to your branch. And until today, there are some of the bank facilities that if you want to access them, you need to go to your branch. Until today, even though we are in the modern technology, still you're going to have to go to your branch. Okay? And again, you have to make or to place your request at the right time. And the right time here, we mean working hours. That's the reason whenever you visit any banking hall, you'll find there is a notice out there which says opening hours, weekdays, blah, 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 weekends, blah, 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 Sunday and holiday, blah, 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 blah. That is to say, if a bank office does not open on weekends, then you cannot demand payment on weekends. Again, if Rock City Mall is not your branch, then you cannot demand payment from Rock City Mall. You have to go to your branch. I've spoken that based on the old technology. Right now, we are in the modern technology. Banking services have been digitalized, modernized. We're using a lot of technology to offer bank services. Therefore, we have ATMs. Okay, so with the presence of ATMs, you can make a withdrawal 24 hours 7. You can make a withdrawal. However, there is a limitation of a withdrawal that you can make from an ATM machine. Again, there is agents banking services. Okay, you can go to any wakala and make a withdrawal. Again, there is a limit. All right, there is a limit of the amount of fund that you can withdraw from the agencies. Okay, again, due to sophisticated technology, right now you do not necessarily need to go to wherever you open your bank account. Right now, you can make a withdrawal from any branch, provided that it is the branch of your bank. Therefore, if you maintain an account with NMB Rock City, you can make a withdrawal at NMB Morogoro, Dar es Salaam, Moshi, or anywhere. And again, to make the business or the service even better, currently we have these services. Okay, we have the Visa services, we have the MasterCard, we have the Maestro, etc. With this, you can make a withdrawal at any ATM machine in the world. All right. So, due to sophisticated technology, this rule that the creditor must demand payment at the right time and right place slightly has been modified. Again, the creditor must make the demand for payment in a proper manner. Again, this is very important to comprehend. The creditor must make the demand for payment in a proper manner. If you want to make a withdrawal, okay, from the ATM machine, the bank instructs you to have either a debit or a credit card. That is to say, without the debit or credit card, with the correct PIN, you cannot make a withdrawal. That is the way the bank has instructed you to make a withdrawal if you are to access this service from the ATM machine. Again, in some banks, okay, in some banks, if you visit a bank branch, all right, at the teller cube, some banks requires you to fill a withdrawal form, and you have to put the signature that you use the very first day you open your account. Therefore, if this is the signature that you use, and today you sign like this, forget, this is not the proper manner that is instructed by the bank. Therefore, the banker cannot honor your request. If you refuse to fill in the withdrawal form and your banker wants you to fill in the withdrawal form, then again, the banker won't honor your request. Therefore, you need to adhere to these instructions. Now, banker's-customer relationship can be that a pledger and a pledgee. What does this mean? A pledger or a pledge is when a customer promises, entrusts a certain asset to serve as a security for the loan. For instance, I take one of my assets, let's say a motor vehicle, and pledge it to a bank. The asset, not necessarily a motor vehicle, can be a plot, a house, share certificate, etc. You pledge it to a bank to serve as a security or collateral for the loan. By doing so, the customer becomes the pledger and the bank becomes the pledgee. Now, in this relationship, in most cases, there is a transfer in possession. And like I give you my computer, you give me the loan. When I finish the loan, you give me back my computer. The asset or security will remain with the bank until a customer repays the entire loan. That is to say now, the pledgee will have an actual control of the pledge asset. So if it is a share certificate or a bond certificate, okay, if it's a share certificate or a bond certificate, then this bond certificate or share certificate will stay with the customer for the entire tenure of the loan. The moment you finish your loan, it is then and only then the banker will give you back that asset you pledge. Now, what happens if you do not repay back the loan? If you do not pay back the loan, the pledgee has a right to sell the pledged asset in order to recover his fund. However, the pledgee is strongly advised to give reasonable notice to the borrower. Before you sell, ensure that you have notified the borrower. And again, ensure that you have issued a public notice through media, can be newspaper, radio, and TV. Do not just rush to sell the asset without fulfilling these conditions. If the customer sues you, then you're going to be in for it. Again, bankers' customer relationship can be that of trustee and beneficiary. Who is a trustee? A trustee simply means an individual or entity that holds the property for the beneficiary and the profit earned from this property on behalf of that beneficiary. In another way around, I should say, a trustee is not supposed to benefit from the asset that are kept under his or her trust. So during the entire times of this relationship, okay, the title of the items deposited to your bank will remain of the customer. Please understand this, okay? Please understand this. Under trustee beneficiary relationship, title to all assets that are deposited to the bank, okay, remains to the customer. Under the pledgee relationship, okay, when the customer pledge their assets to the bank, remember there is a transfer in possession. Therefore, even the document of title will have to be transferred to the bank. So it's different. With the trustee, also there is a transfer in possession of the asset, but the title to the asset is kept by the customer, which is contrary or the opposite to the pledgee relationship. Now, trustee can be created against both movable and immovable properties. Okay, trust can be created against both movable. Movable simply means the items that can be carried to a bank. And immovable properties, those are items that cannot change position, like my house, a plot, piece of land, plants, machines, etc. Those are the items that are immovable. Bankers' customer relationship can be that of bailer and bailee. We call this bailment. Okay. Now, bailment is a contract for delivering goods by one party to another to be held in trust for a specific period and returned when the purpose is ended. Please pay attention to this because there is a thin line between bailment service and trustship or truster and beneficiary relationship. Bailment is a contract for delivering goods by one party to another to be held in trust for a specific period and returned when the purpose is ended. The bailer is the party that delivers the property to the bank, and the bailee is the party to whom the property is delivered. Therefore, if your customer delivered some jewelries, okay, let's say a diamond necklace, for whatever the reason he or she will mention to you, you as a banker becomes the bailee and the customer becomes the bailer. But what is the difference now between the bailment service and the pledgee or truster-trustee? The bailment contract can be done only in respect of movable items or movable property. Right? This is the difference. Otherwise, there is a thin line, like I said before, there is a thin line between these two services. Again, the bailer, there are two types of bailment services. we have gratitude. We have gratitude Bailey, and there is Bailey for reward. Okay. Gratitude offers this service for free. Reward for a fees. So it depends with the policy of your bank. A bank can keep my items for free or at a certain fees. Hypothecator and hypothecatee. Again, pay attention to this. Too closely related with the previous one. Hypothecation is to pledge personal property as security for a debt. Now, look at this. With a pledge, okay, with a pledge, a customer trusts or entrusts his assets, personal property or personal assets, to a bank to serve as a security for a debt or as a security for a loan. Likewise, in hypothecation is the same thing. The customer entrusts personal assets or property as a security for a loan. However, with the hypothecation, there is no transfer in possession. No transfer. Okay, no transfer in possession. That is to say, a customer can hypothecate crops in farms. You do this a lot. Crops in farms can be hypothecated. Goods in shelf, okay, can be hypothecated. Therefore, I insist with the hypothecation, okay, with hypothecation, the customer can entrust the bank movable or non-movable properties in order to get a loan. To be in a safe side, usually the banker will want to retain the title. Agent and principal, that is when a banker serves as an agent. That is to say, a banker performs some services on behalf of the customer. We call them agent services. Now, what are the services that are offered by a bank on behalf, that are done by the bank on behalf of the customers? You know, banking business has both primary services and secondary services. Secondary services, sometimes we call them auxiliary services. Most of the auxiliary services, a banker serves as the agent of the customer, and the agent becomes the principal. For example, buying and selling of securities. The other day we discussed about buying or bidding for treasury bills and bonds. The customer instructed the bank to bid, the banker bids. That means if the banker bids, then the principal has bid. So the banker is serving as an agent of the customer. Collection of checks, dividends, collection of bills, or promissory notes. If a banker collects these items on behalf of the customer, it means the banker is the agent of the customer and the customer is the principal. Acting as a trustee, attorney, executor, correspondent, or representative of a customer, it means you as a banker, you are an agent. Banker as an agent performs many other functions such as payment of utility bills, insurance premiums, handling tax problems, etc., depending with your contract. Also, for instance, we have this standing order. Standing order, or sometimes we call them standing instructions. Okay? I know that every 24th, okay, of a month, every 24th, I'm supposed to pay for DSTV. I don't need to wait for the DSTV to cut off. I've filled a standing order with my bank. That is, every 23rd, the banker will debit my account and pay DSTV. And this will continue for as long as my account has a credit balance. So in this circumstance here, following the signed standing instruction or standing order, the banker is serving as my agent. That's how it plays out. Advisor and client. That is whenever a banker offers an advice to the customer, the banker becomes an advisor and the client is the customer. However, there is a caution over this. That is to say, do not force the customer to take your advice. Let the customer make their own decisions. Do not influence them for no reason whatsoever. Mortgager and mortgagee, that is when a customer or a third party, okay, mortgage or charges, we use the word professional, we use the word charges, okay? When the customer charges his landed property, for example, a plot or a house for a loan, then the customer becomes the mortgager and the bank becomes the mortgagee. This relationship will continue for as long as the customer has not yet fulfilled his mortgage contractual obligation. In this setting, the banker will always retain the title of the asset. The moment the customer has duly fulfilled his contractual obligation, then the title to the asset will be transferred to the customer. When we come to discuss security, then we're going to discuss two types of mortgage: the legal mortgage and equitable mortgage. And you will see why bankers prefer legal mortgage over equitable mortgage. Now, we are now done with the basic types of relationship between a banker and a customer. Now let's see the implied terms in this relationship. Let's discuss now duties or obligation and the rights of these parties following those types of relationship that we have seen. What are the duties of the banker to a customer? We mentioned a few. Number one, a banker is supposed to comply with the customer mandates all the time. If the customer issues specific instruction, okay, to the banker, if the customer issues specific instructions to the banker has to comply. The banker must comply. Number two, the banker has a duty to receive money and collect cheques and bills for the customer. In case the banker has become aware that customer's signature is being forged by someone, or someone is trying to tamper with the customer's account, a banker has a duty to inform immediately the customer about the incident. And that is the reason, for example, if a customer wants to utilize bank services through digital applications like the apps or ATM machines, if the customer misses password 3 times, the ATM machine can either block the card or swallow it for good. Nowadays, you guys have gone even further. If someone make a withdrawal, you send a text message. This amount has been withdrawn from your account. If you are not the one who have done so, please call this number. You are doing all that in order to comply with this one. Okay? So back then, it was all about checking, or if someone come to withdraw, try to forge the signature. But now you have gone even further. You have expanded this duty to ensure that customers' fund is protected all the time. And this way, you continue to earn the trust of your customers. Again, a banker has a duty to pay customers on demand. Remember, customers' deposit is subject to demand withdrawal. Therefore, at any given time, if the customer has made a request for withdrawal, you as a banker needs to honor customer's request, provided that the request is not ambiguous and it has been done in the prescribed manner, and also the customer's account has sufficient fund. A customer cannot demand a withdrawal for the banker to honor while the account has a zero balance. The banker has a duty of secrecy, call it confidentiality, at all the time. This duty is everlasting. A banker is supposed to keep secret customers' information. You should never reveal your customers' information. However, this duty has some exemption. We're going to discuss them shortly. A banker has a duty to issue passbook to the customer. For all those who have been in the banking industry for quite some time, you know the meaning of a passbook. I understand nowadays in our country we no longer use the passbook, but still, for instance, in India, passbook are used to date. So a banker has a duty to issue passbook whenever the previous passbook is full or it is outdated. Conversely, a banker has a duty to issue a bank statement to a customer. So every month, you guys supposed to send a bank statement to a customer. A banker has a duty to exercise reasonable care when paying or collecting checks. This is done so in order to protect the customer and as well the bank's position. That is the reason there's a lot of procedures, okay, if or whenever a customer comes to withdraw a check. But I'll ask you guys this question. However, I do not want you to answer or to give me the response right now. There is this thing you call checklist. Are you doing this under the law? Yes or no? And if you are doing this under the law, then what is that law that guides you or that protects you? Every time you hear, we cannot pay you because your check is not in the checklist. Is there any law that protects you guys from doing this? Think about it. A banker has a duty to give reasonable notice before ceasing to do business with a customer. There can be a number of reasons. Okay, just like in this ordinary relationship, like, okay, maybe let's say you are dating someone and for some reasons the interest that you have is no longer or does no longer exist and you decide to call it off. So don't just keep quiet or disappear like that. Inform the other individual. Likewise, a banker, if a banker has lost interest for any reason, if the banker has lost interest with the customer and decide to terminate the relationship, then the banker needs to notify this customer because the customer needs to make some other arrangement. Again, we're going to have a detailed discussion over this later. Now let's get back to the banker's duty of confidentiality. Banker's duty of keeping secret customers' information. Confidentiality simply means the promise not to divulge the customer's information. Essentially, the banker is protecting the privacy of the customer or the interest of the customer. This duty is everlasting. That is, this duty will continue even if a customer has closed a bank account. If a banker fails to observe the duty of secrecy, the banker will be liable for any damage that might occur. And a reference is made in Etana versus National Provisional and Union Bank of England. This case was ruled out back in 1924. A banker revealed Mr. Turner's information. Turner gets fired by his boss. And guess what? Mr. Turner decided to sue the bank for revealing his secret to the boss. And the banker was supposed to pay a sizable amount to Mr. Turner to compensate for the damage caused. Therefore, you are not allowed to reveal customers' information. That's the reason, for example, if I deposit a check and for some reasons the drawer's account has no fund, you do not say insufficient fund. You don't say insufficient fund in case of a bounced check. But if I go to the ATM machine to withdraw, you straight tell me insufficient fund. At the ATM machine, the receipt printed reads insufficient fund. Why? Because you assume that the one who is making a transaction is the owner of the account. Therefore, you have a right to inform me whatever is going on with the account. But in case of the check, if I come to deposit the check, you know that the one who deposits the check is the drawee, not the drawer. So you cannot inform the drawee affairs of the drawer's account. That's the reason you respond, refer to the drawer. You don't say insufficient fund. You simply say refer to the drawer. So if I see refers to the drawer, me as a professional banker, I understand what is going on. But probably the customer in question might not understand what this means. And you are not obliged to translate this for him. You simply say, please go talk to the drawer. That's it. So you have a duty to keep secret customers' information. The duty of secrecy is not absolute but qualified. I will say again, the duty of secrecy is not absolute but qualified. What does this mean? This means that There are some instances that the bank may give your information to the third party, whether you like it or not. Bankers has a duty to keep secret customers' information. However, this duty is not absolute but qualified, meaning that there are some instances where the banker will have to give out your information to the third party. Now, what are the qualifications for the divulge of the duty of secrecy? Number one can be express consent. Okay, express consent. That is when a customer in writing authorize the bank to reveal its information to a third party. We call it express consent, disclosure at the will of the customer. Number two, when the customer gives the consent to the auditor, because when the auditor is performing his duty, at one point they will have also to check bank and reconcile with the bank statement, maybe with some other invoices and financial statement they're preparing. That being the reason, you need to give cooperation to this particular auditor. If the customer asks the bank to act as a reference, your referee is required to reveal your information. Okay? If you write me as your referee in your CV, it means you authorize me to reveal your information. If the bank serves as the guarantor, if an individual is a guarantor, let's say Freddie has taken a loan from a certain bank, Bank XYZ, and Bank XYZ, alongside the asset, alongside the security that serves as the collateral, wants the loan to be guaranteed. And so I ask, for example, Miss Grace to become my guarantor. Then the guarantor can obtain your information, Freddie's information, from XYZ Bank. Status inquiry. That is implied consent. Yesterday, one of our friends talked about foreign bill. She said, before you discount the foreign bill, you need to perform status inquiry. Therefore, if this is done, the banker can reveal your information to the other bank that is asking for such information. According to the Income Tax Act, okay, there are some customers who submit financial statement A. Okay, this customer prepare different sets of financial statement. They can have up to 3 sets, even 5, depending with their intentions. Financial statement A is prepared specifically for asking loan from bank. This financial statement usually indicates that the customer is making supernormal profit. The business is good, so that they can get a loan from a bank. When it comes to paying tax, then they prepare or they submit financial statement B. This is specifically prepared for tax assessment. This one usually shows that the customer has earned small profit or severe losses. All right? Therefore, you as a banker has a duty to inform authorities that this customer is lying. This is according to the Income Tax Act. Failure to do so, the banker will be liable. Similarly, when the court needs any information regarding the customer, the banker is supposed to reveal such information to the court. You know, in many countries, the court order supersedes a lot of issues. So again, a banker can be compelled by some governing laws, such as Anti-Corruption Act. This happens a lot. I think 3-4 years ago, you guys must have witnessed some of your customers' account being confiscated by the government. Like, the customer will be summoned and asked to explain, where did you get this money? I'm a public servant, okay? I'm a public servant. For some reasons, you check in my account, you find like I have, let's say, 2 billion without explanation. Then you are supposed to report to PCCB. Anti-Money Laundering Act, because there are some issues for terrorism or money laundering. So Anti-Money Laundering Act authorizes the banker to reveal your information or any other act that will be in operation. Again, if the banker is asking to offer its opinion against a certain customer, it can reveal your information. Or if the banker is protecting its interest, for example, the banker has issued a certain loan to a certain customer, and this customer has defaulted. Now, if the customer has defaulted and all efforts to recover the loan has not yielded the results, then the banker can result into recovery. Now, during the recovery, the banker uses what? They use these auction agencies and some lawyers. So as a customer, don't complain that a third party has been given you information. No. Why? Because the banker is protecting its interest. Again, to protect the public interest. That is, for example, you have seen your customer is receiving sizable amount from abroad. It happens a lot. You know, right now there are some schools that teach students terrorism. In some countries, there are some civil war. And all these activities needs to be financed. Now, how the hell these rebels, for example, receive money? It's through you, bankers. So you have the duty to protect the public interest. If you see a customer receiving an amount that is unexplainable, you have to report to the appropriate authority. Again, when the government calls upon the bank to give information regarding a particular customer, okay, I'm sure you guys remember some few years back, the government asked for information, bank information of Airtel. So Airtel is a very good example. The government requires all bankers that are keeping Airtel bank accounts to report to the authority. And I'm sure you did so. Why? Because you are complying to the government instruction, and so Airtel cannot sue you. Then there is a garnish order. What is a garnish order? A garnish order is an order issued by a court of law addressed to a banker instructing the banker to withhold payment. Okay? The garnish order instructs the banker to withhold payment of money belonging to a certain bank account of an individual, your customer, until that particular customer has satisfied some claims of the creditors. So you as a banker, you might receive this order from the court. Once you receive this order from the court, you are required to comply. That is to say, you cannot release the money until the court has directed you to do so. There are two types of garnish order: ordinance and order absolute. Ordinance is issued by a court or on a specific banker ordering not to release any funds belonging to a particular customer. That customer is hereby referred as the judgment debtor until further order is issued. And at the meantime, the judgment debtor is requested to appear before the court for further proceedings. For example, in some court proceedings, particularly when employees, it happens a lot, employees vis-a-vis employer. If the employees win and an employer is supposed to pay them, sometimes the employer starts doing some delaying tactics. So employees can ask the court to issue ordinance. So the entire amount of fund, for instance, if this account has, let's say, 100 million, ordinance might require the banker to withhold the entire amount, do not release anything. Then this employer can supposed to appear to the court for hearing. Now, once the hearing is over and the ruling has been issued, and then an order absolute will also be issued. Order absolute is issued by the court to the banker, where it authorizes the banker to keep a certain amount and release the rest. For example, if ordinance required the banker to retain the entire 100 million, and after the court proceeding, it has been ruled out that only 80 million will be used to pay employees and 20 million will remain to the employer. Then order absolute will require the banker to retain only 8 million and release the 20 million. Now, there are some circumstances the garnish order can never apply. What are the circumstances? Number one, if the account of the debtor is a joint account. If account of the debtor is a joint account, If it is Freddie that is supposed to make payments, but the account is Freddie and Salema bank account, then garnish order cannot apply because this money also belongs to Ms. Salema, who is not part of your court proceedings. Number two, the account of the debtor is held by him in the capacity of trustee. If the debtor is a trustee, is holding that account as a trustee, remember, under trustee relationship, a trustee is not supposed to benefit. From the asset of the trustee or beneficiary. And remember, he is keeping the assets that have been kept under his trust. Therefore, you cannot issue garnish order, you cannot apply garnish order over a trustee account. Again, the bank is informed that the debtor has previously made an official assignment of his balance in favor of a third party. It happens sometimes. Like, for example, the problems is between employees versus Freddie. And Freddie somehow a word has leaked from some of the trusted employees that some of the employees are going to take you to the court. For that reason, immediately Freddie assigned his bank account to Mr. Edie. Then by the time the garnish order is issued, the account is no longer owned by Freddie but Mr. Edie. Then the garnish order cannot be applied. The count of the data reveals a debit balance. If the account has no money, then you do not have to hold it. For what reason? Now let's see duties of the customer. Number one, a customer has a duty to exercise reasonable care when drawing cheques to prevent forgery and alteration. Number two, the customer has a duty to keep safe all checkbooks. Three, the customer is supposed to notify the bank if we actually know that someone is trying to forgery either his signature or his account. Number four, a customer is not supposed to draw cheques without sufficient balance. We do not entertain bouncing check. Again, bank services is not for free. Therefore, a customer has a duty to pay reasonable charges for services they receive. I'm going to add another duty here. The customer is supposed to inform bank about changes in his status. Again, a customer is supposed to inform bank about changes in address. Again, a customer is supposed to read bank statement all the time. Okay. A customer is supposed to inform bank changes in his status. For example, you open an account when you were a student. Okay. You open an account as a student. Now you have been employed. So your status has changed. You are no longer a student. You are an employee. You must inform the banker. That's the reason also to enforce this. From time to time, a banker will conduct KYC to the customer. You open an account as a single. Now that you are married, you need to inform the banker. Again, a customer is supposed to inform bank changes in the address. Okay, you were in Moshi. Your address has changed. Your physical address has changed to Dar es Salaam. You have to inform the banker. The banker has a duty to provide the customer with the bank statement on a monthly basis. Likewise, a customer has a duty to read the bank statement. If anything occurs, you as a customer cannot say, I didn't know. This is not an excuse. You're supposed to read the bank statement every now and then. Now let's see rights of the banker. What are the rights of the banker? The first right is called the right of lien. What is a right of lien? A right of lien is defined as a right to retain property belonging to a debtor until the debtor has a full discharged the debt. That is to say, we have a customer who have come to a bank for a certain loan. For example, this customer has been granted 10,000 loan. Okay, and what did he pledge? He pledged a diamond necklace. A diamond necklace which is worth 70,000 USD. Therefore, a banker has a right to retain this diamond necklace until this customer has fully repaid this loan of 10,000 plus its interest. Now, there are two types of a lien. A lien can be particular or general. What is a particular lien? A particular lien confers right to retain goods or an asset that is associated with specific or particular transaction. For example, our customer goes by the name Sai. This customer is your esteemed customer. She took the first loan of 10,000 USD and security she pledged, the security she pledged is the diamond necklace. The diamond necklace is worth 12 USD. Then, after some time, she came over and took another loan. Okay, she's your esteemed customer. She took another loan with 15,000 USD. This loan was unsecured. We have two types of loan. The loan can be secured or unsecured. Unsecured loan, that means there's no security, no collateral. So Misai has just taken unsecured loan worth 15. I don't know under what arrangement. You don't ask me this. Now, here is the situation. Misai is supposed to complete the repayment of both loans within 2 years. Since the unsecured loan was too high, she concentrated on repaying back this loan to the extent that by the time 2 years have lapsed, this loan was not fully repaid. Okay, let's say this loan, she still owed the bank 4,000 USD. But even though there was less concentration on the first loan, but by the time 24 months have lapsed, this loan was completely repaid. The principal amount and the interest both fully repaid. So Misai still owes the bank 4,000 USD. The bank is not allowed to retain the diamond necklace so as to force Misai to fully repay this loan. Why? Because Misai executed a particular lien, and since you bankers accepted it for a particular lien where the diamond necklace was a security for a loan of 10,000, then you cannot use the same diamond necklace to enforce the repayment of the 4,000 which is left. You have to give back, because under the contract of security, the moment the customer has fully discharged the loan, you have to give back the security, discharge the security. So you cannot retain the security. Why you cannot retain the security? Because it was a particular loan. The security was pledged to serve as for the collateral for the 10,000 and not for the 15,000. I hope it's clear. Now, what about the general lien? The general lien allows the bank to retain goods or assets not only in respect of a specific debt, but also if there are some other debts. So back to our example where Misai has taken a loan of 10,000. She pledged a diamond necklace which is worth 12,000, and also she took another loan of 15,000 which was unsecured. She fully repaid, she fully repaid the 10,000. She fully repaid the 10,000, but for the 15,000, she still owed the bank 4,000. Then the banker is authorized, under the general lien, the banker is authorized to enforce the repayment of the 4,000 using the diamond necklace, which was pledged to serve as a security for loan number 1, which is the loan for 10,000. That is the reason we as banker prefers the general lien over specific lien. Before I move further, I would like to share something with you, but let me finish here. The banker can exercise his power of lien in respect of the following issues or items. Number 1, bonds and coupons belonging to the customer deposited for collection. Okay, so if for unsecured loan, Misai had nothing to serve as collateral, or the diamond necklace for some reasons is not sufficient to repay back the money she owes the bank, still the banker has a right to retain bonds and coupons that the customer has deposited for collection. Number 2, customer security left over with the banker after paying the loan. We've already discussed this in my previous example. 3, any security given by the customer for the purpose of covering a loan. We discussed this as well. However, the banker cannot exercise the general lien over the following. Number 1, securities and money deposited for specific purpose. Okay, so specific purpose sometimes is the question of the court to rule that what is a specific purpose. 2, a banker cannot exercise this right over a separate account maintained by the customer, which is known to the banker as a trust account, because a trustee is not supposed to benefit from any asset that is supposed to be owned by the beneficiary or that is kept under his trust. Again, the banker cannot exercise the power of lien for documents submitted for getting a loan. For example, while you guys, let's get back to the example I gave you about Misai. Misai still owes the bank 4,000 USD. And for some reasons, there's nothing that you can retain. And during your morning session, your credit officer goes like, you know what, sir? Misai has recently submitted some documents in application for the loan, and in supporting of her application, she has given us the title deed of her house. We can retain this. That's not acceptable, because you're supposed to retain something that has come in the normal course of business. So a property that the customer has pledged to serve as security for a particular debt, again, you cannot retain it. Or you cannot retain properties on which the customer has no title. For example, you just summon Misai to your bank for a discussion on how she can clear this 4,000 USD. And she arrived there in, let's say, a very fancy motor vehicle. Okay. What you do is you retain this motor vehicle, trying to enforce the repayment of this 4,000. And Misai goes like, you know what? that motor vehicle belongs to Salome. And she even give you a proof that this motor vehicle belongs to Salome. A banker cannot go like, you know what, you and Salome will finish your business over there, but we are going to retain this motor vehicle. The banker, if you do so, you'll become liable. It's not authorized, it's not allowed. Again, you cannot exercise your power over the contents of a safe deposit locker that belong to the customer. Why? Because the items do not come to you in the normal course of business. Again, when credit and liability are not in the same right, you cannot do this. Or a property coming in by mistake, in which is placed with the bank to cover an advance that is not granted. Again, this one was held in the case between Lucas and Dorian. Commercial litigation, okay, from finance and law advocates. Now, my interest is over this one. Recent court decision on banking law, obligations to repay the loan. Okay, I want for us to refer to this case. Okay, bank to recover the loan from only the properties pledged by the customer. In the High Court commercial case between Bank of Africa Tanzania Limited against Rose Miyago Asea, which was judged by Judge Mruma, the court was of the settled view from that banks cannot recover unrealized amount of loan from other sources or properties of the borrower. Okay, I'm sure you guys, you are aware of what we call precedence case. There are some of the cases, if they resemble a certain case that was ruled some years ago, then the judge will simply decide this case following the precedence case. That's how it is. And that's the reason, even here, when we are talking about some duties, obligations, rights, blah, 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 we also refer to some cases. That in this case, it was defined a banker is, or a customer is, etc., etc. So we call them precedence case. Now this one now has become a precedence case. That is, the High Court said bank cannot recover unrealized amount of loan from other sources or properties of the customer. Now let me read the case for you. In this case, the borrower was Rose Miyago Asea. So the borrower defaulted the loan repayment that was granted to her by Bank of Africa Tanzania Limited. Consequently, the bank appointed the auctioneer to dispose the mortgagee property. Okay, so apparently Miss Rose pledged a house for a certain loan. The property was disposed of in a public auction. Okay, the property was disposed in a public auction, and it fetched only 100 million Tanzanian shillings. But the outstanding loan remained at Tanzanian shillings 71.8 million. So that is to say, in total, Miss Rose owed the bank 171.8 million. That is what she owed the bank. But when the bank sold the property simply fetched 100 million. Therefore, there was an outstanding balance of 71.8 million. And this 71.8 million continued to accrue interest, and together with other charges to the tune of 100 million.1. Remember, this case went to court back in 2017. Okay, in 2017. But the loan was before 2017. Therefore, still the banker was counting the interest. That's the reason, after selling the house, this was the outstanding amount, and since The amount was not yet settled, so it continued to accumulate interest, right, to 1.1 million. The bank made necessary effort, including filing the case so as to recover the loan, including selling of the borrower's other properties that were not mortgaged. Okay? I say again, the bank made necessary efforts, including filing this case so as to recover the loan, including selling of the borrower other properties that were not mortgaged. Remember, Miss Rose pledged what? She pledged a house. Okay. Now, if she pledged a house, that house becomes a particular lien. The banker never executed general lien. The banker executed a particular lien. So what happened? In his decision, the judge viewed that by signing the mortgage agreement, the plaintiff bank had accepted that security was sufficient to secure all such sums that will be due and on the bank. That's the reason in lending we insist that you ensure security covers the loan at least 3 times, so that such a thing will never happen to you. I say again, by signing the mortgage agreement, the plaintiff bank had accepted that the security was sufficient to secure all such sums that will be due and owing by the borrower to the bank. The court reasoned that if consequently it is found that the value of the security does not cover all, it is falls short the amount specified in the facility letter. If the bank disposes the security at the price less than specified amount, then the bank has to blame itself. I say again, the banker has to blame itself. Why the bank has to blame itself? Because you are the one who value the property. So the banker has to blame itself for undervaluing the security either before accepting or at the time of sale. And therefore, it cannot come back to the court to seek to recover the loan by other means other than the security accepted. So you see, the security is termed as what? Particular lien. The court cautioned banks and thus finally ruled that it is high time now for banks to be aware that once they decide to exercise their statutory power of sale under the mortgage agreement and the sale does not derive the amount secured, they cannot come to court with the view of having recovered the unrealized amount by attaching and auctioning other properties of the mortgagor. From this decision, the High Court made it clear that banks cannot enforce their recovery measures to other properties other than what has expressly been agreed upon between the borrower and the bank. That is the reason now I told you earlier to be in the safe side, execute a general lien.